Court is resumed. Please be seated.
My plan for this afternoon would be to go until 3:15, then break, and then go till 4:30.
Thank you.
We left off before the lunch break, talking about the would have and could have, and we made explained our argument about why the Anishinaabe would have invested and what they would have invested in and the rates they would have invested in. But I want to sort of just continue on with the possible, well, what else could have happened? And you might recall that there was the evidence of Booth and Kersner about what might happen and how individuals would have spent their money. And the first point that I want to make about that is really contained at paragraph 217 of my reply argument. And that has to do with, you might recall, I don't recall if it was in my opening remark. I think it was in my opening remarks, we talked about the millionaire who gets, who before he's a millionaire, he buys 1 cup of coffee, and then when he gets more money, he doesn't buy 1,000,000 cups of coffee. And so that past spending patterns are only as good as if it's a similar amount of money, but when one all of a sudden gets in a huge cash influx, one does not assume that the spending pattern would be the same. And indeed, that's exactly what Justice Zinn said in the Lilly and Apotex case at paragraphs 66 and 67, which I set out verbatim in my reply argument at page 217. And he makes the point at paragraph 66, if the additional sum that comes in is close to or exceeds the historical sum, then common sense informs that it is more likely it would have been treated differently. And he considers an illustration of Joe, the everyman Joe, who has an annual income of $50,000. And if he receives a 0.5% increase in pay, it's unlikely his spending and investing habits would change significantly. But if he wins the lottery, all of a sudden, Justice Zinn says, it's more likely he'd buy a new car, take a vacation, pay down his mortgage, or invest significantly in a retirement plan. When considering what Joe would do with a large cash injection, the past is not a reliable guide. And the same is true here. We don't have an example, an instance where the Anishinaabe were paid the proper substantial sums owing as calculated by Stiglitz and Hutchings. So we don't know, there's not evidence of what they would have done. There is evidence, yes, of with meager amounts of money, what did the Anishinaabe do? And with those eager amounts, the evidence actually showed that about 93% of it was saved and not spent, that they were able to not draw down on capital during the Depression. And also to keep in mind, the plaintiffs, when they would have spent that money on their membership, the evidence from Stiglitz and Hutchings and from Booth and Kersner is that they would probably spend money on human capital, which actually has rates of return that exceed the 60-40 blended rate claimed by the plaintiffs.
Okay, can I ask a couple questions here?
Yeah.
So I had noted when I was reading that I thought that Booth and Kersner had said that the past spending pattern showed savings of 93%. And so, yeah, the saving rate was 93%.
That was the conclusion when you looked at both capital and revenue, yes.
And so I was wondering whether you were challenging then the continuation of habits. Like you give an example that their patterns would have changed.
Yes.
and changed from 93% to what, 100%?
Oh, you mean in terms of what, how much they would have saved?
Right.
W- Yeah, Ms. Lewis is reminding me to make sure the court knows that Booth and Kersner's evidence was not that it was 93%. It was, they had only looked at the revenue account, and their percentage of savings was less, but I believe it was in cross-examination that we demonstrated through their own data that in fact, when you include in both revenue and capital accounts, in aggregate, on average, 93% was saved.
So they, so there, that reminds me, so hence there was that cross-examination because you were. Okay.
Right, but the thing is that the question would be, what would someone with have spent the money on, and if one accepts that one is looking at the types of spending on that would have happened on infrastructure and human capital and relieving poverty, those expenditures are not truly consumption. Those are investments in people.
Right, and that's the second point.
Right, that's the second point.
And so I wanted, my question on that was, I believe the evidence was from Professor Stiglitz on what the return was on spending / investing in human capital.
Right.
And did the witnesses Booth and Kersner accept that, or were they asked that, the rate of return?
No, I don't believe that they accepted Stiglitz and Hutchings' opinion on the rates of return on human capital, but their own data on human capital actually exceeded the 7.2% average, I believe.
Their data on the return of investment.
What they said was return on human capital. I don't have, I think Canada, maybe even in opening, had a summary sheet. Okay, well, I'm being told it's exhibit 42. Yeah, Berth Kuzner's interest rate with all the various machinations for saving and consumption. But I think it's fair to say that Booth and Kersner had a view that the rate of return would be lower than what Stiglitz and Hutchings believed.
The rate of return on investment in human capital.
Well, certainly on consumption and human capital.
On consumption.
Right.
Okay.
Well,
And
but
they just, and is, am I right that there's some debate on the labeling of whether certain items of expenditure should be labeled consumption or or investment in human capital?
yes, that for example, if you invest in education, I think Booth and Kersner would say that gets a higher rate of return. But if you invest in feeding someone and if it's spending on an apple when you're really hungry, Stiglitz would say that's really valuable. And Booth and Kersner said, well, all you get for that is inflation. Right? For consumption, you only get inflation.
I didn't remember. I thought, just my memory, I thought all you got was an apple.
Well, you still got well, yeah. So in 1900, if you had money that bought you an apple,
Oh, the return.
you'd get the same apple, and you'd still have one apple. But what you wouldn't have is you'd be, remember the cross-examination, but yeah, you were hungry for 73 years. You know, what did you get to eat? Which is nothing. I think we went through that in cross-examination. But to sort of come back to your question, Stiglitz and Hutchings had a difference, not only in terms of the rate of return on human capital, but also an important distinction between at what rate of return is there on consumption. For Booth and Kersner, consumption is really just brought forward by inflation. For Stiglitz and Hutchings, it's no. you're not really consuming. There's a value to lost consumption, which again is the Arthur Hosius position that was accepted, I believe, in Hyatt case from the specific claims tribunal.
What's Arthur Posius?
Arthur Hosius is an economist that he's since passed away.
Could you spell it, please?
Hosias. No? Damn. Okay, wait, my friend, Hosios. Arthur Hosius.
Got it. Thank you.
Yes, thank you, counsel. But he was the one that within the specific claims context and a number, I think it was the Hyatt case in particular, testified and in the Southwind case as well, but his opinion in Southwind at trial was not the preferred opinion. But in the Hyatt case, he explained, as did explained that there is a rate of return on foregone consumption, which is the same point I took you to earlier today, that if you're sitting there and you can either eat an apple or invest it at 11% in the market, if you eat that apple, you must think that the return you're going to get on eating that apple is at least 11%, rather than selling the apple and investing the money.
Well, that's an economist's view. As I said, it's not immediately. I don't connect those dots in the same way.
Oh.
But it's like the tree in the forest.
Yeah. Well, no, it's like a tree in the forest that still has values, for sure. Yeah. But it might be an economist, but it's also a common sense view, honestly. It's not something that is that intuitive for someone like me who's not an economist, but having read some of Arthur Hosius's work, having read Stiglitz and Hutchings' reports, I have come to be a convert. And I think I better understand it now.
I can follow it. It doesn't immediately
right
tell itself to me.
So just to sort of recap then, what Stiglitz and Hutchings say is that the rates of return, if you actually go down the route of trying to identify all of Booth and Kersner's various areas, and you try and ascribe what Stiglitz believed was an appropriate interest rate, you come to an amount that is very, very close to the 7.2%. They weren't exact, but they were actually very close in the final analysis. And I believe Mr. Hutchings may have had a chart on that.
Can you start with that again? If you identify all of Booth and Kersner's various areas?
Yeah, I'm not sure if this is in the Hutchings or Stiglitz reply report, but somewhere either in their reply report or in their evidence, and I believe it's in one of their, in a bar chart of, which I can't remember where it was in. Oh, there we go. It is now up. So that is part, who's, that's right in their reply report. Okay, are you able to identify the page number, because I cannot read it?
But I can see that it's page 56 of 80, and it's table 5.
Yes, and so that graphically demonstrates Stiglitz and Hutchings' report and opinion, where they said, look at, if you actually factor into the Booth and Kersner model, the proper rates of return, you actually, the orange and the yellow are so close. And the orange is actually Stiglitz and Hutchings, and the yellow is Booth and Kersner. So Booth and Kersner is actually a tiny bit higher than 7.2% on average.
And what page did we say that was? 56?
Page 56 of Exhibit 4.
And this is the Hutchings reply report?
The Stiglitz and Hutchings reply report, Exhibit 4.
Thank you.
Yes, thank you, counsel. Thank you, Ms. Lewis. The next point then, unless there's any questions about could have and would have, I wanted to discuss some of the positions of the defendants that I thought just ran afoul of the reasons in the amended judgment, which is my next topic. So the first one is claiming that it is the Crown who decides on the form, level, and aim of sharing. We've already taken you through to our position and understanding that the judgment and the reasons identify that it is the responsibility for the court to identify the form, level, and aim of sharing. Secondly, major error in Ontario's work or by its experts is identifying that the expenses that support resource rents are relevant instead of looking for expenses that support relevant revenues. A third major error is found at tab 5 of my compendium, which is Stiglitz's smell test number 1, declining sharing over time. So we say that it was a position of Ontario's experts and a position taken by Ontario that is inconsistent with the facts and the bargain reached by treating the treaty bargain as though it was a one-time commercial sale of an asset purchased by the Crown in 1850. And the result of that analysis leads to the discounted cash flow analysis. And if you look at tab 5, it's part of the trial demonstratives of Professor Stiglitz, page 67 of his demonstrative. And we're looking at page 19 of the compendium today. And you'll see that by 1877, this sharing arrangement to look after each other under a risk adjustment approach becomes 50% in 1877, 20% in 1911, and 1% sharing in 2019.
Let me get to it, please.
Yes.
So the smell test, as described by Professor Stiglitz, was that a sharing model that declined to practically zero over time doesn't pass the smell test.
It is completely inconsistent with anything that has to do with a wait and see approach. Inconsistent with the bargain that was actually reached, the facts. Inconsistent with a bargain in which the parties would share in the future opportunities and future potential. So it is not a theory that is consistent with the facts, evidence, or the judgment.
I'll ask you the question, but it will end up going to the Crown's. But you might be able to help me. Is the risk adjustment approach, as you understand it, and this is connected to a question I had for you earlier, based on a presumption that there would be some determination in advance of what the annuities would be? as I recall, the foundation for the risk adjusted approach was that the Crown officials would have to take into account all of these contingencies going forward and all of these risks, and they would have to adjust what was paid out because they couldn't know what all these risks would be, that this was a huge uncertainty waiting for them. Do I misunderstand that?
Well, I think you've got it half right, sorry to say. The half you have right is that yes, it has to do the risks of what might happen in the future. But I don't think it's tied to a fixed annuity, right? If that was the first part of your presumption.
Yes, so I was wondering, what's it fixed to then, this having to predict?
Okay. What it's fixed to goes to our next major error they made, which is to say, after the facts, remember the facts are, no one knows what this is going to be. In Bodway and Smart's analysis, they say, we can assume that they had perfect foresight in 1850, and they would have said to themselves, I've now examined Bodway and Smart's analysis of the net Crown resource revenues. I see that it's minus $4.5 billion in 2021 or 2020. Question, now that I know that it's going to be a loser, how much will I pay for it? And in order to...
How much will I pay for it in what?
In 1850.
No, but in a promise on annuities or in the money up front? That's what I'm saying. What was it? How much will I pay for it? They had two things to come up with: the money they paid up front and the annuities.
No, no, this is to value what they should be paying as part of the annuities, right? So they're saying to themselves, what they're asking the question, and I believe it was either Bodway or Smart actually admitted this in cross-examination, that in effect what they're asking themselves is, if this was a one-time purchase in 1850, what is the territory worth? What would I pay for it if I was a reasonable person? And in order to make that kind of determination, if you're a purchaser of an asset, you ask yourself, what's this asset going to be worth in 10 years? And you have to factor into risks. And so you factor in risk adjustments and depreciation. And you say to yourself, well, if I know this asset's going to be worth $10 in 10 years, I now can figure out mathematically what I would pay for it today. If I know it's going to be worth negative $4.5 billion, I can figure out what I would pay for it today. The answer should be zero. And yet they did enter into a treaty, which kind of contradicts their theory. But mathematically, this is what you arrive at, right? And you would still arrive at this sharing model, I suppose, if you try to discount it by future contingencies that you're assuming, no matter what, whether it's minus 4.5 or minus 3 or minus 1 or minus 2. All right, so we have up on the board, thank you, Ms. Lewis. This is from Exhibit 61. This is Bodway and Smart's report, paragraph 73. In order to estimate the risk-adjusted present value of the resources in the treaty territories in 1850, we need two sorts of information: future expected NCRRs and the risk-adjusted interest rate. 74, the only information we have on expected future NCRRs is the information about what actually occurred. So notwithstanding that no one knew what was going to happen. In Bodway and Smart's hypothetical world, they say, let's use what actually happened. And then they answer the question, what actually happened with the answer? Well, it would have been worth nothing, negative 4.5 billion. So respectfully, they've got a double error there, if you will. They err in coming up with this calculation of negative 4.5 billion, and they err in claiming using perfect foresight in 1850 as if that's the value of the NCRRs. That's the value of the NCRRs to 2019. Yeah. Ms. Lewis wants me to make sure that you understand that, and that well, I guess maybe that I understand that the risk adjusted approach is not the so-called Vidal and Anderson approach. That's a different approach, and that assumes even further assumptions that aren't warranted in this case, which I think I'm going to get to that momentarily. So the fourth thing I said was postulating that the Crown had perfect foresight in 1850. The fifth is postulating that the Crown took all the risk and the Anishinaabe took no risk because, as I understand it, they say, well, the Anishinaabe had pound 500 guaranteed to them. Well, remember that pound 500 really, one way of looking at it could have come from the funds on hand already. And you might recall that there was, back in phase one, a discussion with Dr. Von Gernot on day 66, March 14, 2018, in stage one, where we were discussing what money had actually come in. And the court may recall that there was a reference in Robinson's instructions to pound 7,500. And there was also a reference to 11,000 pounds having come in. And that 11,000 pounds, actually, I put it to him, how did it come to be? Why 11,000 pounds, and why did the Crown use 7,500 pounds as saying that that was the amount available, even though 11,000 pounds came in? And together on the stand, we observed that the ratio of what was available to what actually came in was about 1/3, 2/3. And I had put it to Dr. Von Gernot, does this mean that the Crown is basically saying, yes, we got in 11,000 pounds and our expense ratio was about 1/3 or about 33%? To which Von Gernot, I believe, and I think Ms. Lewis will find the transcript references, Dr. Von Gernot said, that's a pretty interesting coincidence, but I'm not sure if that's actually a meaningful expense ratio. It might just be coincidence. The interesting thing about it is that 33% expense ratio of expense, if that's what it is, if you bring in 11,000 gross and you have 7,500 to spend, that's pretty close to a 31.9% expense ratio. Now, maybe that's just coincidence, but a happy coincidence for me standing here today. In any event, that was a bit of a digression, because the point I was getting at is if there's 11,000 pounds that they had before the treaty, and you only needed about 22,000 pounds to fund on a capitalized basis the 1,100 pounds in total, that was, the floor. Well, it's not much of a risk at all. And Stiglitz made this point as well, that the monies that were coming in, there was virtually no risk that the Crown was taking. And I don't have a citation for Stiglitz saying that, but I am confident he did say something to that effect. While Ms. Lewis is looking for the Von Gurnet, the citation, which
I'm just going to catch up.
yeah, okay. It was day 66.
Thank you.
Okay, so while Ms. Lewis is looking for that, the sixth thing, I think it's an error for the Crowns to postulate that there can be no compensation for lost opportunity to engage in a process, because to do so would require the Crown to accept that it owes a fiduciary duty to the plaintiff. I think that's mixing up apples and oranges. 7, postulating that the lost opportunity to utilize annuity monies that would have been paid in the past are to be measured by the cost of the Crown's foregoing borrowing, as opposed to what the Anishinaabe lost opportunity was. This, I think, is a fundamental misunderstanding of what the law requires. In examining a plaintiff's loss, one does not look at the cost of performance of the defendant. One looks at what the plaintiff lost. The point was in effect brought home in the Southwind case, although it was an equitable case. If you turn to tab 6 and at page 22 of the compendium, the court makes the point, or the majority of the court makes the point at paragraph 10 about Canada's argument at the time was that, well, you know, if Canada had performed its obligations, it could have expropriated the land as a public work under the Indian Act provisions in force. So the land should be valued at expropriation. And the court says at paragraph 11, well, that's flawed. By looking solely at the amount that they would have received if Canada had complied with the general law relating to expropriation, the court gave the trial judge gave no effect to the unique obligations imposed by the fiduciary duty. The trial judge improperly focused on what Canada would likely have done, as opposed to what Canada ought to have done as a fiduciary. Now, so the point being made is you don't look at what Canada would have done or could have done. You look, and this is a feature of assessment or calculation of damages, you look at the plaintiff's loss. And the plaintiff's loss can be very different than the cost of performance to a defaulting defendant at common law.
Were you looking at paragraph 66?
Nope, I was looking at paragraph 10 and 11.
Oh, thank you.
Yeah.
Thank you.
Yes, you can ask me, and I might even be able to remember to do it. The eighth thing that I wanted to say is postulating that Vidal and Anderson came up with the idea to invest annuity money at band trust account rates and to only use the capital, sorry, only use the interest and to leave the capital invested. What Vidal and Anderson said in the passage that Baudouin and Smart rely upon was that there would be investments in the funds, and we agree that the funds are the band trust accounts, if there was no treaty. If there was no treaty, then we would have had individual proceed surrenders, and that's when the money would go into the band trust account. So they've got the facts wrong. And on that score, I'm not sure if how they came to that conclusion, whether it was their interpretation or whether they were assisted by any other expert, but whoever they relied upon, or whether it was their own interpretation, it's wrong. Another error is that Ontario's experts include expenses that were not incurred by the Crown for the purpose of supporting relevant revenues, but would have been incurred anyways for other reasons in any event. And a prime example of this is the railways. The evidence from I think it was the Vast and Magnificent Land, and there was one other document, made clear that mineral discoveries followed the railways, which were built for other reasons. I'm grateful to Ms. Lewis, who have now given me a couple of citations. Just going back, and I apologize for being a little bit disjointed here. The reference to von Gernit's testimony in stage 1 was day 66, page 9854 and following, where we discussed the expense ratio of 33%. And when I mentioned that Professor Stiglitz had advised that the risk to the Crown was de minimis, the words he used was de minimis. This is at Stiglitz transcript, pages 470 to 471.
From the transcript.
Yes.
Thank you.
That's stage 3 transcript.
Well, it can't be from Professor Stiglitz. If it was page
It's stage 3.
Oh, sorry.
Yeah, I hope it could be. I remember him being there.
Sorry.
Yeah. Depends which stage 3 you're talking about. That's stage 3.
Only then?
The final thing that, and look at, I'm not giving an exhaustive list here. I've made my argument in my main and in my reply. I'm just trying to highlight some of the ones that sort of stuck out as particularly egregious or telling. Finally, I would be remiss if I did not also note that Booth and Kersner's model simply does not follow the facts and the evidence in this case. I come to a new topic now, the role of resource rents. And I start with the observation that the treaty focuses on what the treaty territory produces. And the point I want to make about this is what the treaty territory produces is something that is objectively determinable. True, one has to strip out competitive returns to labor, supply, and capital, but valuing what the territory produces is precisely what Stiglitz did. It's worthwhile on this to return to his evidence, which was, I think, nicely captured in his demonstratives, which is at tab 7 of our compendium. And I just want to run through those momentarily, in a moment. And I think we might be able to do it briefly, and I'll wait for the court to get there.
Yeah, thank you.
Okay, so at page 29 of the compendium, Stiglitz's slide deck 11, which is exhibit 5 to stage 3. He started out with an example of a gold mine, and on the first page, he has a picture of gross revenue, and then in the next slide, identified capital, suppliers, and labor. In the third slide, page 31 of the compendium, he explained that workers have to be paid at least as much as they could earn if they didn't work at the gold mine. He then explains, slide on page 32 of the compendium, page 14 of the demonstratives. He talks about the suppliers must be paid a competitive price. On the next slide, he explains that capital must earn enough profits to get a competitive rate of return, and the remaining excess value is the economic rent generated by the gold mine that can be captured by the landowner. At compendium tab, page 35, Stiglitz demonstratives, page 17, he moots the question, why are rents relevant? He says, rents are the appropriate basis for valuing the RST Anishinaabe contribution, the lands and its principles, the lands and its resources, a general economic principle of sharing. Sharing must be informed by the relative contributions of the parties. Now, that is an economic principle. It's also one that I consider to be common sense. That's one that is not unique to economics, I say.
What, this principle of sharing?
The principle that when sharing must be informed by the contribution that people make. That if the two of us come to want to make an arrangement to exploit a resource, and I own the resources and I bring the resources to the table, that's a factor that we would consider as we negotiated. What did you bring to the table? Let's consider what I hesitate to say a fair share. I'll say a share that is fair, a share that is just, a share that is appropriate. And then Stiglitz. Yes.
You and Professor Stiglitz deliberately use the words informed by, as opposed to is determinable.
It's a factor. It's not the be all and end all. If that's what you mean. Yeah. You know, one could conceive of a situation where someone says it would be appropriate to make my share be what I brought to the table plus some return on that. There could be any machinations, but if you're thinking about economic theory and principles of sharing, one of the factors, and I say one of the factors this court has to consider is, well, what did the Anishinaabe bring to the table? It just so happens to be coincident with what the economic rents are, but that's one way to look at it. So where do the rents go? Professor Stiglitz then explained that the Crown, as manager of the lands and resources, has the ability and responsibility of collecting rents. And there were multiple ways the Crown could and did collect rents. The Crown collects a share of rents directly using mechanisms like the mining profits tax, stumpage, water rental fees. The Crown captures another share of rents indirectly through general tax mechanisms like income taxes, including the corporate income tax. The Crown may also transfer rents to other parties through regulations and other policies. And here he gives an example: policies favoring cheap electricity prices from hydroelectric generation, were a transfer of rents to industry and other electricity consumers. When the Crown does not capture the rent, does not alter the value of the land. It only changes who receives the value. So this is why we say that it's important to understand that the value of the treaty territory is what the Anishinaabe brought to the table. And he continues on with the example of the gold mine over at page 38 of the compendium. He has the 4 boxes: the rent, the capital, supplies, and labor. And the next slide is an important one because it sort of explains what happens, that you have in rents, some part of the rents are captured by the Crown directly through direct fees. Investors can capture some of the rents, suppliers may capture some of the rents, and labor may capture rents as well through higher wages and salary. And then Professor Stiglitz at the next slide, compendium page 40, explains that the Crown also captures rents indirectly through general taxes and other factors of production, recapturing some of the rents not initially captured, and he eventually gave evidence that that's 25 to 35%. So all experts, save for Hamal, agreed that the concept of resource rents is the appropriate concept to start with, because all the economists agreed that what the Crown captures by way of NCRRs, the direct net Crown resource revenues, is a portion of the resource rents. And if you want a citation for all experts except Hamal, that's at our argument pages 329 to 330. Sorry. Paragraph 329 to 330 of our main argument.
Can I just ask something here?
Yeah.
When, and it may be that I asked this question of Professor Stiglitz as well. This notion of the rents that are not captured by the Crown in any way.
Okay.
They stay in the hands possibly of the mine owner or the investor. So the mine owner or the investor pays out those fees that we have referred to as NCRRs, fees directly captured by the Crown. The mine owner pays those out. They pay mining royalty tax, or they pay those things out.
Okay.
They pay those out. I'm looking at slide 21, page 39. So what comes out of that yellow box, the rent part of it goes to the Crown. That's the pink bar at the top. What the Crown captures directly.
Right.
The next bar, and it's the biggest bar, I'll call it green, is what the investors get on their return. And
No, you're wrong about that.
okay,
It's what they get on their returns that are higher than necessary to fairly compensate.
okay, so that's my question. There's first of all, in order to write that sentence, one has to be able to fix, presumably in some non-controversial fashion, what is the amount that's necessary to compensate them?
Correct.
And then is it a judgment call that this green box represents something, some amount that some experts or some third parties would say is higher than what is necessary to compensate them? And is there a suggestion, this I think was at the root of some problems I had understanding things, is there a suggestion that that is capturable, that if investors make more than they need, returns more than necessary,
Yes.
that the Crown, that is capturable by the Crown?
Yes, that I believe that was Stiglitz and Hutchings' evidence that it is capturable by the Crowns. And the counterpoint that the defense experts said is, in the real world, you could never capture 100%. Right?
I remember that part.
Yeah.
But I thought whenever anyone said you can't capture 100%, it was all about tax avoidance, tax, whatever the other
Tax
legal term,
transfer,
head offices or
tax avoidance, tax evasion.
tax avoidance.
Yeah, Hutchings' response to that in his report, saying that that's not really a proper factor because that's already taken into account, baked into the calculation. So that's not a valid concern. But you might recall the evidence was that, the best example of capturing all the rents is, I guess, in Norway, where they have a rent tax of some sort, I think it was.
So does that mean, does it follow that there is a stipulated rate of return above which you pay it back, or it's a penalty on your taxes?
Okay. Remember what we're trying to do, what Stiglitz and Hutchings did, is they asked themselves the question, how do I value the productions from the treaty territory?
Mhm.
What is the resources actually worth? And in order to do that, you need to go through their process of identifying what the reasonable rates of return are on capital, on suppliers, on labor. And that's what they did in their opinion. Their opinion does include in a number of assumptions about fair rates of return, because what they have the data showing what the assets that were exploited or the resources that were exploited were.
Back end way of calculating what the investors were getting back.
That's right. And I believe that they, used a number of assumptions that they thought were reasonable. Now, you didn't hear a lot about it in cross-examination because it wasn't cross-examined on. But you'd really have to go into their work papers and start breaking down their work papers or having someone explain their work papers if there was a challenge to their methodology. But their methodology does, as far as I understand it, include in assumptions about what a reasonable rate of return is for capital and suppliers and labor.
Let's say there's no controversy about
Yes.
what the reasonable rate of return is.
Okay.
But the proposition then, as I understand it, is that the economic system that we have currently allows rents greater than necessary to compensate the investor, allows rents to stay in the hands of potentially third-party private operators, and doesn't go to the Crown. I hesitate to say that the capitalist system, but whatever the system is that allows the price of hardwood to rise and fall in a certain way and allows the operator to charge more or greater than more than necessary to get a greater than necessary return back for the investor.
Yes.
Would still allow, in your model or in the model of Professor Stiglitz, that some of that money would be captured one way or another in a way that we don't have yet, or it would be accounted for in Professor Stiglitz's way, so that the Anishinaabe shared that, what I believe Professor Stiglitz called the excess profit.
Right. I think there's a couple of things I think we should be clear about when we talk about what Professor Stiglitz was saying. First of all, remember that he was explaining that what the Crown does by, let's start with the first proposition. The Crown, as the owner of the resource, has an interest to try and capture 100% of the resource rents, right? That's what you would do in a perfect world. You would try and capture 100% because that's the value of the resource. And if you're the owner of the resource, you'd want to sell it for 100% of its value. Now, if there are market conditions that prevent you from being able to do that, so for example, if you're worried, for example, that, well, if we charge too much stumpage fee, the company's just going to up and leave and go to Louisiana and cut the trees in Louisiana, and we'll have no activity here. What Professor Stiglitz said to that is, as long as there are returns that exceed by 1 penny, and I think I'm paraphrasing, exceed by 1 penny what someone else could get a fair rate of return on their capital or supply or labor, they will come and exploit the resources if there's a fair rate of return to be had.
Okay.
So in their economic theory, if you wanted to capture the rents, you actually could capture the rents. Now, related to that, but not the same point, Stiglitz and Hutchings said, look at.
Sorry, and that's an answer to people would avoid, or they would go to Louisiana.
Right. So the answer is, if you ask a capitalist, you have a choice of making no money or making a small amount of money. What would you do? You'd make a small amount of money. If you have 3 choices and you've got 3 producers, right? You have 3 of them, one's going to go to Louisiana. The first one, it's going to be a race to Louisiana at that rate. But the second one is going to say, well, I might as well stay and make some money. So it will be exploited as long as you give them a fair rate of return. Now, there are some real world complications that I guess I'd have to concede would, in the real world, you'd factor in to say, well, what if there's only 2 producers? Well, I guess that's possible. Is there enough of a spread, enough of money for someone to enter into the market, right? Because capitalism will tell you that if there's money to be made, someone's going to make that money. If it's not the fellow that took off to Louisiana, then it's going to be someone else who's going to enter the market. Now, that's in a pure economic sense. In the real world, I think we have to concede that, there has to, if I'm looking at an investment and I haven't invested in building a tree cutting machine yet, or haven't hired my labor yet, and I see that I can make 1 penny, right, and only 1 penny, I might not get into the business, right? So I think that's a fair consideration for you to take into account. But the situation we have is the economic theory that I don't think was cross-examined on or refuted by Mr. Stiglitz, by Professor Stiglitz, that in the economic world, there would be someone to fill that gap. But Professor Stiglitz actually went further, and this was, I thought the main point to take. He said, look, you wouldn't even have to do that. You wouldn't have to take away the profits that you're giving away. All you would have to do is charge fairly for the resource rents and give them a subsidy, because you're in effect doing the same thing, right? And remember the graphic, was it Mr. O'Riven, we put the graphic of the pie?
So if I understand that, by charging fairly, you would charge the real price.
Yes.
Per tree.
Yes.
Their expenses would go up, profit would go down. And if you want to encourage them for economic development reasons, you would give them a subsidy.
Right. And exactly that. You might remember there was the happy guy smiling with the pie and a bigger pie. Implicit versus explicit subsidy. Was that to Mr. O'Riven? That was to Mr. Bodway, we put it. Right. So this is a question of the subsidy issue, and that you can actually achieve the very same result that happened in reality by simply saying, what we're going to do is we're going to give a subsidy to these people, because, well, that's what you're doing by not charging the fair market value of something. You're subsidizing industry. Now, is it appropriate to subsidize industry? Well, maybe there's lots of good reasons. Why would the government subsidize industry? Why would you spend or give away electricity? Why would you give a railway? Well, but there's all sorts of good public policy reasons why you might choose to do that. You might get more income tax. You might get more personal tax. You might employ people. You might, if you're building a railroad, you'll build a cross-country railroad that'll unite a country and keep Americans from taking over, keep the Fenians at bay, right? So these are all very real and important things for the government. We don't deny that. But the question is, given the bargain in 1850, should that be at the expense of the Anishinaabe? We say no. If the Anishinaabe are partners in deciding on how resources are used, yes. But to exclude them from the decision-making and to say you have to suffer the consequences of our giving away lands, waters, and minerals and trees, and it comes out of only your pocket, while we, the government of Ontario or the government of Canada or the province of Canada, while we get rich and while we make sure that our friends in the railroad companies, running their railroads, receive fat subsidies because of political cronyism. I believe that word came up in the evidence. That's wrong, that my clients should have to pay for that. And that's, boy, this is now probably the 9th time I'm referring to Mr. Carney. This is precisely the solution that Carney fixed upon. And that's why I said that Professor Stiglitz's approach about implicit and explicit subsidies is very much in line with what was mooted by the Commissioner of Crown Lands in 1858.
In a simple example.
It was a simple example, but one with tremendous implications. And if I might say, demonstrates the honor of the crown. Or at least what in 1858, one crown official thought the honor of the crown required. On the issue of whether, sorry, was more questions?
Yes.
Yeah. On the issue of whether the crown also captures part of the resource rents indirectly, the economists Stiglitz, Hutchings, Mintz, and O'Riordan and Bodway were all in agreement that the crown captures part of the resource rents indirectly as well. The only holdout was Smart, Professor Smart, who on cross-examination, in response to a question about whether the crown captures rents indirectly as well as directly, said it was possible. And that's at cross-examination, page 6643, 6647. We say, and ask the court to prefer the opinions of the 5 other economists to the equivocal admission by Professor Smart. Now, in their reply argument, Ontario sought to refute that their expert, Smart, had essentially conceded the point of the crown collecting rents indirectly, without mentioning that the other 5 experts all agreed that they do. And with respect, I looked at Ontario's argument, and it appears to me that they raise a non sequitur jab followed by a straw man punch, neither of which I say landed a blow. So let's deal with the non sequitur punch. At paragraph 66 of their reply, Ontario posits, contrary to the plaintiff's assertions at footnote 248, Smart never admitted that it's possible that the crown captures more rents directly than indirectly, clearly viewing it as a speculative suggestion. And Ontario cites Smart Cross, pages 6645, lines 5 to 23. Problem with that argument is at footnote 248, we did not claim that Smart admitted that it's possible that the crown captures more rents directly than indirectly. We happen to think that that's true, but not only did we not say that, neither did Mr. Smart. So at footnote 248, we said Smart conceded that it was possible that the crown captures rents indirectly. So we were accused of saying that Smart admitted that it's possible the crown captures more rents directly than indirectly. Didn't say that. I don't know how Ontario got that, but it's wrong. And I would say that in fact, if one looks at the transcript, Professor Smart does indeed admit to the very possibility that we put to him. At page 6647, lines 3 to 11, Professor Smart affirmed that resource rents exist independently of who captures them. Ontario further replied at paragraph 66 of their reply that Professor Smart viewed the possibility of rents being captured indirectly as speculative. Now, I have to say that I think it's fair, and undoubtedly Ontario would characterize Professor Smart's concession this way as him saying it's him believing it's speculative. But to be clear, Professor Smart did not use the word, I take it to be speculative, when he was cross-examined. So he didn't use those words. I think Ontario could make the argument, well, that's what he probably meant, but he didn't say that. As for Ontario's straw man argument at paragraph 66, Ontario first ignores the fact that in his testimony during cross-examination, Bodway admitted, as we point out in our argument paragraph 386, and at transcript pages 7708-7713, that the Crown does indeed capture part of resource rents on top of what is captured directly. So see page transcript 7710, lines 10 to 12, and 7711, lines 5 to 15. Ignoring this admission given by Professor Bodway in cross-examination, Ontario replies at paragraph 66 of their reply with the straw man argument that at our footnote 247, we allege that Bodway admitted in his article, Taxation in a Rent-Rich Economy, which is Exhibit 76 in Phase 3, is inconsistent with his report opinion that the Crown does not capture rents indirectly. Now, we stand by our argument that a fair interpretation of the article taxation in a rent-rich economy is indeed inconsistent with the suggestion that the Crown the Crown does not capture resource rents indirectly. But we never argued at footnote 247 that Bodway admitted his article was inconsistent with his opinion. Although we say we think it is self-evident that it is in fact inconsistent. And you might recall that—
When you say his opinion, the opinion you elicited on cross.
No, you might remember his opinion in his report was, together with Professor Smart, was the Crown actually only captures rents directly. I'm saying that's false. I'm saying it's false because Bodway admitted it was false. And I've given you the citation where he admitted it. And what he didn't admit that his article Taxation in a Rent-Rich Economy, Exhibit 76, he didn't admit that that article refutes his
opinion.
His opinion in his report. I say it does, and the reason why I say it does is if you look at that article, and I'm not going to turn it up, but it's at page 259 of Exhibit 76. He writes that included in the corporate income tax recovered by the Crown are a portion of the resource rents. Well, there you go. Now would be a good time. Oh. Just before we break, I want to go back to a point, and Ms. Lewis has kindly alerted me to that the court should be assured that in their opening report, Exhibit 3, Stiglitz and Hutchings explain how they calculated the excess profits in their rent calculation. It's Appendix C.2.B, and if you look at pages 115 to 124. Pages 115 to 124 of Exhibit 3. So it's all there, but it's all very dense. Well, for me, for me.
Okay. So we'll take a break.
And now would be a good place to take a break.
Let's try 15 minutes.
Order, all rise. Court has stood down for 15 minutes.
60. No way.
This court is resumed. Please be seated.
Before the break, we were dealing with whether the Crown captures parts of the rents indirectly. Now I want to turn to the quantification of the resource rents captured indirectly. Stiglitz and Hutchins estimated them to be between 25 and 35%. You can see our main argument at paragraphs 189, paragraphs 258 to 371 is what I have. Reply, argument 196, 196 D and E and footnote 88. D is in David, E is in Edward. And 196, reply 196 D is in David, E is in Edward, and footnote 88. Ontario, during Mr. Hamal's testimony, sought to elicit testimony from Mr. Hamal, a non-economist, to refute the percentages captured in respect of hydro revenues. The court may recall the plaintiffs objected. What we objected to was not the ability for the defendants being able to bring forward such evidence, but bringing it forward without at least some expert report touching on the subject being brought forward from Mr. Hamal, even at this late date. In effect, not in effect, expressly, Ms. Lewis invited the defendants in open court to bring that evidence. And if you want to see the exchange, that's at transcript page 5492. We observe that Mr. Hamal testified on April 27th, 2023, approximately 2 months after Mr. Hutchins left the stand on February 22, 2023. Mr. Hamal, notwithstanding that those 2 months in between, provided no written basis or rationale for an opinion that resource rents are not captured indirectly, or that a percentage that is captured is other than the 25 to 35% that Stiglitz opined upon. Meanwhile, Professor Smart did not testify until May 17th, almost 3 months after Hutchins left the stand, and Bodway took the stand on May 29th, again, close to 3 months after Mr. Hutchins left the stand, and well after Professor Stiglitz left the stand. Now, I found it actually odd, after being invited by Ms. Lewis to produce a report from an expert to refute the percentage opined on by Mr. Stiglitz. None of the experts did so. Neither Bodway nor Smart took the opportunity to refute that evidence, nor, for that matter, did Professor Mintz or Ryden. No Crown expert sought to refute that percentage. And I suggest to the court that there's a very reasonable explanation why no economist challenged Stiglitz's percentage, because his percentage is probably right on the nose, or probably even conservative. There was ample opportunity and an invitation from Ms. Lewis on behalf of the plaintiffs to bring that evidence, and it was not brought, and the court should not assume that that evidence is incorrect. So rents are a good
Just remind me, I'm
Yes.
just looking at these dates. Mr. Hamal was for,
April 27th, 2023.
before Professor Bodway.
Yes, and before Professor Smart.
Okay. And that invitation to bring evidence was made during that objection to Mr. Hamal, right?
Yes, at transcript page 5492. And, you know, the plaintiffs, I think we're being extremely fair to say, look, we don't object to you bringing the evidence, just tell us what it is, give us a basis for it. But that wasn't forthcoming. And just to sort of square that, the issue of and they head this off at the pass, maybe it's anticipating a defense a bit, but Professor Stiglitz, in giving his opinion as to the percentage, he wasn't straying too far from his report. His report is there were rents, part of the rents collected indirectly. He didn't in his report identify the exact percentage. It came up in cross-examination and it was related naturally to, well, Professor Stiglitz, if you say that some is collected indirectly, how much? That's not straying beyond his report. And to the extent that it was, there was no objection taken at the time, ample opportunity to refute that evidence. And the fact that no economist sought to tells me something about the reasonableness of that assumption. Reasonableness of that opinion, sorry. Yeah. So rents are a good metric because they identify what the treaty territory produces, which is the litmus test of the treaty, the productions from the treaty territory. Resource rents, secondly, resource rents is equal to the economic value of the productions of the treaty territory after you strip away returns to capital and labor and suppliers. Resource rents is an independent and objective measure of the productions of the treaty territory that were available to be captured by the Crown. A note, difficulties in precisely quantifying the amount in dollar terms of resource rents is not an impediment to their use. Precision is neither to be expected nor is it legally required. What is important is that a reasonable approximation of what the resource rents were permits the court to have a fair appreciation of what we have called the full size of the resource pie available to be captured by the Crown. And on this point of whether precision is required, I want to refer back at page 48, paragraph 219 of our reply argument, where once again we return to Justice Zinn in Apotex, where he was careful not to confuse proof of causation with quantification of loss. And this is, we say that once causation is proven on the balance of probabilities, the absence of clear proof of quantification is not a bar to recovery. Referring again to Zinn J in Apotex, Zinn wrote at paragraph 48, while I find that the burden is on Lilly to prove that the court, prove to the court on the balance of probabilities what it could have and would have done with the lost profits had it received them when it should, I also accept that quantifying the damage in a hypothetical world cannot be exact. The United Kingdom Supreme Court recognized this in Morris Gardner versus One Stop, a 2018 case. At paragraph 37 of that case, he quotes, "Evidential difficulties in establishing the measure of loss are reflected in the degree of certainty with which the law requires damages to be proved. As is stated in Chitty, paragraph 26-015, where it is clear that the claimant has suffered substantial loss, but the evidence does not enable it to be precisely quantified, the court will assess damages as best it can on the available evidence." That principle is, you'll find repeated, I believe, in Wadhams on contracts and any other major text on contracts. Oh, there's another one. Has the court caught up?
Yes, thank you.
Yeah, I said Wadhams, if I don't have it before the court, but the standard text, they're under the heading Certainty, Chapter 13 of Wadhams loose leaf edition, Law of Damages, 2022 Thomson Reuters, under the heading Chapter 13, Certainty. And I believe you will find some explanation of the principle just cited by the English court and by Justice Zinn in the Apotex case. I don't think it's controversial at all. The next point, 100% of the resource rents is a really good proxy for what the Anishinaabe brought to the table on a wait and see approach, measuring the economic value of the productions of the treaty territory on an as and when or if and when they are produced basis. 100%, next point, 100% of the net resource rents is the proper metric by which the court can know what the upper bound of the resource related revenues are that the Crown could have captured without incurring loss in the real world that actually happened. True, in a perfect world, the Crown would capture 100% of resource rents, but in a less than perfect world, they would still seek to and could capture a portion of those resource rents left on the table over and above what historically they did capture. Next point, Stiglitz and Hutchings' estimation of net resource rents is a conservative one. We discussed in our argument conservative elements, our main argument at paragraphs 487 to 496. And there are Mr. Hutchings' demonstratives where he explained the conservative elements. Page 48 of the compendium. So at page 48 of the compendium, the court may remember seeing this chart of the fact that for 40% of the time, rather than using rents as an estimate, actual revenues were used for some of the data. So that makes it conservative. And there were other conservative elements used by Mr. Hutchings in their NCRR analysis as well.
I'm just catching up.
Yeah.
What was the 40% of the time, please?
40% of the time, 40% of the time, Mr. Hutchings utilized actual revenues instead of rents in his rent calculation. And that's depicted graphically at page 48 of the compendium.
Because of the different periods and different periods that add up to 40% of the time.
That's right.
Is that right? Okay.
So he says, I use actual Crown revenues as conservative estimates of rents for a substantial period of the time. And when he says actual Crown revenues, he's referring to only the direct Crown revenues, right? His NCRR calculation. The next point is that Stiglitz and Hutchings did not seek to quantify the optimal resource rents that could have or should have arguably been generated had different policy choices been made. They measured the value of the resource rents actually and historically created in fact by the decisions on use that the Crown made over time in the real world. This, as we had said earlier, is to be contrasted with the opinion of Professor Bodway that it is the optimal possible resource rents that, while difficult to estimate, is the best accurate reflection of the value of the lands and resources. And that citation is Bodway Demonstratives, Exhibit 74, page 29, and the last bullet of his slide.
Would you mind? I'm just going to go back to timestamp 1555 on the transcript. I was trying to figure out what that sentence was. They something the value of resource rents actually and historically created. They measured, they counted the value of resource rents.
Oh, they measured the value of the resource rents
Got it. Thank you.
actually and historically created in fact. And then
And you use the word actually for sometimes directly and indirectly.
we're talking about rents, so it's it's not the NCRRs, or it's not what the Crown captures. It's not what just the Crown captures directly and indirectly. It's an rent calculation, which is the whole suite of value that's available to be captured by the Crown.
Okay.
And that I was trying to contrast with what Professor Bodway opined was the optimal possible. Sorry, it was Professor Bodway opined that it was the optimal possible resource rents that, while difficult to estimate, he said, would be the accurate reflection of the value of the lands and resources. And the citation I gave for that was Bodway Demonstratives, Exhibit 74, page 29, and the last bullet. And I don't know if it would be helpful to go to my compendium, page 41, which is taken from Exhibit 35.1. I wonder if we could go there for a moment.
So is that the last page of tab 8?
It's,
I see that number, yeah.
yeah, I hope it's the only page on, only tab on page 8.
Oh, is it?
Only page on tab 8.
Tab 8, okay.
So it's hard to see where the number is. It's
I've got
under
it. Yeah.
part of the text, but this was Exhibit 35.1, save for, I've added 2 things and I've put them in square brackets on the right-hand side just for explanation for today. The words direct and indirect.
Thank you.
And so remember what Professor Bodway was in effect saying, that if you really wanted to know the value of the lands and resources, you would not look at the yellow amount that Stiglitz and Hutchings measured. You would look at the bar going up to the green, which is the optimal management over time. And so I guess in a sense, you could say that Stiglitz and Hutchings are leaving on the table, so to speak, in their calculations, value that Bodway suggests, if it's important for the court to look at value, this is another, I would call it another conservative element for Stiglitz and Hutchings.
And he uses the word actually again.
Again, those are my words, but
Oh, actually captured?
yeah.
And you mean directly and indirectly, because you say the Crown and others?
Right.
No,
Um,
no, that's just a rents, but not optimal rents.
right. Optimal rents is the green bar.
Got it.
And what I had intended to identify is that in addition to, the yellow bar is rents actually captured by the Crown and others. And we know that the first red bar is what the Crown captured, which we say is about 56 billion. They capture that directly. They also capture some portion over 56 and underneath 126, which we now know is 25 to 35%, which I've used 30% in my calculations, was actually captured by the Crown. But in terms of the value of the natural resources, Bodway says, no, Bodway says, no, Stiglitz and Hutchings don't give enough value to the treaty territory. If you're asking the question, what is the value of the treaty territory over time, you actually should be looking at the green bar, not the yellow bar that Stiglitz and Hutchings looked at. And so that's why I say Stiglitz and Hutchings 126 billion is actually another measure of conservativeness. Finally, for the resource rents are important because it tells us what portion of the resource rents greater than what the Crown did, in fact, in reality, historically capture, but could have captured is. That amount is important because it gives some indication. It's the critical data needed for the court to quantify the loss caused by the failure of the Crown to engage in a process from time to time to identify what the Crown resource-related revenues may have been from the resource rents that were available to be captured. So in three kind of tranches to summarize, we know based on Stiglitz and Hutchings, and again, using 60/40 bring forward, they actually captured directly 56.895. They actually captured another amount, 30% over and above that, that brings the amount to about 77 billion. We saw that from the charts we looked at yesterday. And somewhere between 77 billion and 126 billion, up to 126 billion, according to Mr. Hutchings, and up to some unidentified number, according to Professor Bodway, is the amount that could have been captured optimally.
And this number it's 77 billion, right?
Yes.
The difference between or the 30% of the difference between 126 and 56.
Yes.
That's what gives you.
Yeah. And the actual data is, it's, if you want to find the source of that, you can go to tab 4 and page 15 of the compendium. It's 0.7638 $763 billion. It's at column D of page 15. And the footnote in the reference is to Hutchings Demonstratives Exhibit 11, slide 293, and the reference to his work papers and where it's discussed in his reply report is there for you, should you need to go there. Did the court have a particular?
That's the bring forward value, 763.
No, that's the nominal.
It says nominal in column D.
Yeah, the nominal, let's just go back a moment to that. So what, if you add up the column C and D, the direct and the indirect, you get nominal 1.806. And then if you go over to page 18, you'll see that we've then taken that 1.806 and brought it forward at 5%, 5.3%, and 7.2%. And at the 7.2 60/40 rate, you would get $77 billion. As at
where?
On page 18 of the compendium, very last column.
Thank you.
Direct and indirect. And obviously, if you take into account different interest rates, you get different bring forward amounts, right?
Yes.
But that's where the 77 billion comes from. So if there's no more questions on rents, I plan on leaving rents and going to direct NCRRs.
Thank you.
So I wanted to start off with NCRRs by reminding the court about areas of agreement and disagreement. And again, just mention the conservative elements that the plaintiffs brought to the calculation. So referring to tab 9 of our compendium, I've just reproduced Hutchins' slide deck numbers 18 and following. And so he says, look, there's areas of agreement in the NCRR calculations. He talks about the data sources, the allocation methodology, Crown gross direct resource-based revenues, NCRRs from hydro. And he says, with few exceptions, Professors Bodway and Smart and I agree on attribution of most expenses before 1945. Then he explains the key areas of disagreement. And those key areas of disagreement, there were, the court may recall that there were many small areas of disagreement that really didn't amount to much in dollar terms. But the big ticket items were relevance of forest-related industries, expenses, excuse me, relevance of 2 categories of transportation, colonization roads and railway subsidies, and attribution and allocation after 1945. And then at the next slide, old slide deck 20 at page 44, Mr. Hutchins provided an indication of the small areas of impact, most of which I'm not going to talk about today.
Areas of small impact.
Pardon?
Areas of small impact.
Yeah, areas of small impact. Mining profits tax. Remember, we talked about that yesterday. 0.2% of the province-wide. Logging tax. Even spectrum is a relatively small item given the big picture here. And there's some disagreement on expenses, mining rehab, forest reserves, insect control, and research. And I thought it useful to actually give a sense and to remember the declining importance of direct resource revenues to the pie. And over on page 24 of what was, or page 45 of the compendium, which is page 24 of Mr. Hutchins' demonstratives, you will see a very tiny sliver of direct resource-related revenues. And that in fact, in 2018 to 2019, there's very little coming in from direct resource-related revenues. Undoubtedly, there'd be another 30% of that recaptured through taxes, but even that 30% hardly moves the sliver to any degree. In fact, most of the government's revenues that would give it the money to enable to pay an amount without incurring loss comes from HST, gas, excise, land transfers, corporate tax, personal tax, federal transfers, and all other sundry revenues and health and education taxes. So it's really a tax regime now, not a resource regime. And that there's been a declining importance of direct resource revenues for well over, well, it's been many decades. At page, so I guess the point I wanted to make with this pie is to show that the future of sharing perhaps does need to be renegotiated in light of the change in what's important in revenues. But we acknowledge that until there is a change in agreement, the treaty says what it says. And, you know, that's what unless there's renewal that changes that. We have our bargain, and we're entitled to the benefit of our bargain for the past, and rules to allow us to capture a good portion of that sliver in the future. I also just wanted to remind the court at compendium pages 46 and 47, just how small the impact of Bodway and Smart's criticisms on the treatment of certain expenses that Hutchins made in terms of insect control, mining rehab, squatters' expenses, forest reserves, as compared to the 2% of revenues on hydro. And so I think what Mr. Hutchins was trying to do at slide 212, which is that reproduced at page 47 of the compendium, is to say in his reply report, he explained how relaxing some of his key conservative assumptions would more than offset the negative effect of deducting the expenses discussed on the previous slide. To illustrate, he says, the table below shows the effect of removing my assumption regarding expenses related to direct hydro revenues to align with Professor Bodway and Smart's approach. You might remember that Professors Bodway and Smart said, the public accounts don't identify any cost to hydro. Therefore, Bodway and Smart didn't include any cost to hydro. Notwithstanding that, Mr. Hamal, Ontario's own witness, contradicting Bodway and Smart, said no, there are expenses, and agreed that a 2% ratio was reasonable. That's the ratio that Hutchins used. But the point is that, and I think what Hutchins was trying to get at, and I hope the court appreciates, this is not an exact science. The court is going to be left with estimates of resource rents, estimates of NCRRs, some of which estimates are based on opinions the court should accept, some of which the court shouldn't accept. But to pretend that there is accuracy and that the court has to get every single detail correct is not what the law requires. And we do not encourage you to get into the minutia of trying to calculate each and every one of these elements. We think that it's an effort that is not appropriate because I
have no fear of that.
Okay. Even though, whether it's damages or compensation, we do not believe, the plaintiffs do not believe that precision is realistic given the lack of perfect data that would allow the court to do that. And we're asking the court to do its best as it can under the circumstances. Where I wanted to turn now is to forestry expenses and what the 1975 Timber Task Force report, Exhibit 68, tells us. Is the court ready for me to go on?
Yes,
yeah. At transcript page 6164 and following, in direct examination, Professor Smart sought to utilize a 1975 Task Force report for the purpose of trying to demonstrate that the province-wide numbers that he and Professor Bodway used as relevant to the forest industry were very close to the province's own numbers. Recall as well that this document was only disclosed after Stiglitz and Hutchins had left the stand, so Stiglitz and Hutchins could not comment on it, and could not explain in economic terms why the data in that report actually supports the plaintiff's case. It was left for me in cross-examination to try and elicit that. I did my best. And I believe as we go through the summary of the evidence, you will see that that's what happened. At slide 68, that's part of Exhibit 70. And let's see, where can we find Exhibit 68? Hopefully, page 49 of our compendium.
Tab 10.
Tab 10, page 49, yes. So you might recall this slide from Professor Smart, and he tried to make the point that his province-wide numbers, and I want to always remember he dealt with province-wide numbers, and but to the extent that we compare apples to apples, that's fair. But province-wide numbers of expenses supporting the forest industries were only 14 to 20% greater than the province itself identified. And you see the very last category, it says percent difference. So he tried to make that point.
Okay.
Now, the reason he gave for why the province was 14 to 25% lower than him was because the provincial officials were apportioning administrative expenses differently than he did. So you can see slide 68, compendium tab 10, again at page 49. So we know right away that by his admission, it's Professor Smart's, his methodology of apportioning administrative expenses is greater than what even the provincial officials believed was appropriate. Hence, his expenses are always going to be overestimated. But we say, Professor Smart's errors are not limited to simply overstating administrative cost overhead. As was discussed with Professor Smart in cross-examination, the 1975 task force report highlights what we say are significant errors in his numbers. Firstly, Professor Smart and Bodway did not overestimate from 14 to 20%. They have in fact overestimated province-wide expenses attributable to the forest industry overall by about 45%, not 20%. And the way that you arrive at that is by looking at table 18 on page 57 of the task force document. Which is located on compendium page 52. No, yes, compendium page 52. This is page 57. You can see the page 57 in the gray colored box on the right-hand side. But this is part of Exhibit 68. I'll wait for you to get there. So we're at page 52 of the compendium.
Right, and then you say page 57, but is that just a?
No, it's table 18, and the 57 is the actual page in the task force report.
Oh, okay.
And you
Oh,
can
I
you can see the page 57 there.
But it might be slide 98. Is that what that 98 number is? Yeah.
Yeah, that page 98 is page 98 of our compendium that we gave to Mr. Smart during cross-examination. But it comes from I mean, this is a picture from the actual task force report. And what we did in cross-examination is brought the court and Professor Smart's attention to the red line. And if you look at this, what you can see is that in reality, the province assigned 25% of forest access roads to the forest industry. And if you, it's on the second column, assumed industry share. And under the second row, forest access roads, assumed industry share, 25%. And we know from looking at the data that Bodway and Smart didn't use 25%, they used 100% in their calculations. Remember, these are province-wide. So they're 4 times off, expressed as a percentage, that's a 400% error. They did the same error under miscellaneous indirect management. 25% is what the provincial officials said, but Bodway and Smart in their data set use 100%. Again, off by 4 times or 400%. When it comes to forest protection, again, the province uses 25%, and again, Bodway and Smart used 100%, and again, they're off 4 times. So when you look at table 18, the expenses attributable province-wide to the forest industry in 1967 are not 29.4 million. Where does that 29.4 million come from? Go back to page 49 of the compendium. That's Bodway and Smart's approach in 1966 to 67. It's not 29.4. It's actually 16.16 million. Total cost assigned to the forest industry, 16.16 million. This is a difference of 13.24 million. Expressed as an error rate, that 13.24 million error on expenses of actual expenses of 16.16 million could be described as an 82% error rate. Or if you would prefer, and using a different denominator, it could be explained as a 45% error rate. It just depends how you want to. I guess I could be accused of statisticulation, depending on what denominator you use to try and show the discrepancy, but it's at least 45, maybe as much as 82% discrepancy. Now, this error, to a varying degree, but around the same amount, is repeated in each and every year between 1967 to 1974. And if you look to compendium page 53, you will find calculations that we did and presented to Mr. Smart on the lower end of the scale of discrepancies, and it's anywhere from 42 to 46% error. But the problems with Bodway and Smart's data does not end here. There are yet additional significant problems with the task force data. Now, we observe that Ontario now argues, paragraph 120 of their reply, that Hutchings could have used data from 1967 to 1974 to calculate post-1945 expenses. But data from 1967 to 1974 is not data from 1945 to 2019. It's number one. More importantly, though, please keep in mind that the 16.163 million in 1967, which is 18.8 million in 1968, and so forth, up to 1974, are not province-wide expenses that support relevant revenues. They are province-wide expenses that support resource rents generally and support other downstream benefits that the Crown receives, both in money terms and in other terms. It would be comparing apples to oranges to try and go down that route. Now, I wanted to look at some of the other anomalies that further erode any helpfulness of the 1975 data. And I have a note, let's look at page 55, found at exhibit 70, slide 151 of 161.
And a synonym for 1975 data is this timber something report.
Yes, this data is the 1975 Timber Task Force report.
Thank you.
And if we go to page 50 of the compendium, you'll see the expense calculations. Pardon? I'm at page 50 of the compendium, slide 151 of 161. And I'm suggesting that the biggest problem I just told you is these are expenses that support resource rents and other downstream benefits, everything, not just the resource revenues. But let's take a look at what we see on the table XVI at page 50. It's part of the Timber Task Force report. And the province counts federal contributions as revenue receipts that reduce province's expenses. But Bodway and Smart calculate this revenue receipt as an expense. One, at footnote E, as in Edward, we learn that logging road construction costs are the responsibility of industry, not the Crown, but yet they are included as an expense. At footnote I, as in Igloo, we learn that included in expenses is a portion of which gets charged to industry are such things as, amorphously, I might add, as legal services, information services, junior ranges, youth corps, maintenance and constructions of docks, bridges, dams, locks, bridges, dams, and docks, and also grants to municipalities and grants to conservation authorities. Moreover, recall that these are expenses and do not factor in the recoveries the Crown receives from the fire tax, which would further reduce the net taxes. And to top it all off, none of these province-wide numbers have yet to be subjected to an inquiry as to whether they have anything to do with the Robinson Superior Treaty Territory, nor whether their expense supports a relevant shareable revenue. The monitor is saying that it said, okay, the Crown receives from prior tax, which would further reduce the net taxes. should say, I should have said, and I apologize, further reduce the expenses. Thank you. Now I have a little bit more to say about the fire tax. I don't know that we would get through it all in the next minute or two, so it might be a good time to break.
Okay, let's break for the day. Chelsea, you go off camera. I just erase something. Yeah.
This court is adjourned until September 13th, 2023 at 10 a.m.